Kurt Flehinger is a civil rights and criminal defense attorney, and Tajinder Singh is an attorney at Goldstein and Russell. He is also a contributor for the SCOTUS blog. He joins us from Washington, D.C. this night. Mr. Singh, I'll begin with you. Let's talk about the issue of gay marriage. Nationwide, the tide is moving in favor of same-sex marriage, but the Supreme Court, as you know, is not about tides. What is the legal precedent the court has to examine?
There are a number of relevant cases. The most relevant cases are the court's recent pronouncements on the subject of gay marriage. There's a case called United States versus Windsor, which dealt with the Federal Defense of Marriage Act that I think will be very instructive in this case. And then there are other cases about marriage itself. So there's a case called Loving versus Virginia, where the court recognized an equal protection right to interracial marriage, and that may play prominently in determining whether that right also applies to same-sex marriages. Both of those cases came out in favor of greater rights, and I think the smart money all thinks that this case will be decided the same way.
And Mr. Flehinger, courts also have to protect the minority, and in this case, the minority is very vocal in the sense that 37 states in the District of Columbia have now passed same-sex marriage laws, but the other minority now is the Christian community in the United States, which was once the majority. Which majority does the Supreme Court, I guess, factor in making its decision?
Well, when it comes down to issues of constitutional rights, individual rights spelled out in the Bill of Rights, later on in the amendments to the Constitution, these are rights that apply to individuals. And these individuals, gay people who are trying to get married, are claiming that they have a fundamental constitutional right, the right to marriage. And the Supreme Court has gone along a long time saying that marriage is a fundamental right. And gay Americans are saying it's available to us as well.
But Christian Americans who are opposed to this particular issue say that it's an issue of religious freedom versus individual freedom.
But what these individuals who are trying to get married are saying is the state itself has an obligation, if it is going to confer a benefit called marriage to anybody, it has to do it to everybody. The issue of an individual citizen who has a conscientious objection to gay marriage on a religious basis is something that may have to be dealt with later, assuming that this case comes out and the Supreme Court grants gay marriage. But as to the state, these plaintiffs are saying you have an obligation to provide this to everybody if you're going to provide it to anybody.
Mr. Singh, what happens if the court strikes down the laws in those 37 states in the District of Columbia that now allow gay marriage? Are all of those people then going to be unwed?
So there is no prospect that the Supreme Court will strike down laws permitting same-sex couples to get married. There is a prospect that if the Supreme Court says the Equal Protection Clause doesn't require recognition of this right, then judicial decisions that came out that way will be revisited. There is some precedent from the Ninth Circuit Court of Appeals saying that, once a marriage has been fully performed, it's unconstitutional to then break it apart. And that was in the first round of same-sex marriage cases that we had just a couple of years ago. The result in those states where gay marriage has been legalized by judicial decision would be uncertain, but I suspect that marriages probably would not ultimately wind up dissolved in large numbers.
This issue not going anywhere fast. I want you both to listen to Meet the Press this morning. Rick Santorum, who announced that he is running for president on the Republican ticket, had this to say about any potential court ruling. Take a listen.
We're not bound by what 9 people say in perpetuity. We have an obligation and a right in a free society to push back and get our Congress and our president and rally the American public to overturn what the court wants to do.
So that being said, with all of the announced Republican candidates opposed to the issue of gay marriage in principle, is there a showdown brewing, and I'll start with you, Mr. Flehinger, regardless of what the court decides?
Well, I think that there's always a lot of rhetoric about a heated issue like this, about whether we're going to follow a Supreme Court. In the desegregation cases in the 50s and 60s, there was a tremendous backlash against it. I think in the end, people will end up following this. Senator Santorum is right. We can move to amend the Constitution if that's what he can get the Congress and the President on board to do. But I believe that people will follow the dictates of the Supreme Court if there's a clear and definitive statement that there is a right to marriage.
Mr. Singh, some people are saying that this is the Roe v. Wade of this generation. Regardless of which way the court decides, this is going to be debated over and over for years to come. Do you concur?
No, absolutely not. I think that this issue will be decided. I think, as I said before, most people are predicting that the court will say there is an equal protection right for same-sex couples to get married. And I think that basically in a couple of years, we won't really be talking about this anymore. Until very recent pronouncements in connection with the Republican primary, you haven't even heard Republicans talking about this as a real campaign issue, in congressional elections, for example. This will be the type of issue that will get resolved, and then nobody will be talking about it anymore in about 5 years.
Issue number 2, King versus Burwell, better known as Obamacare. Mr. Singh, isn't this a case where the court will be deciding it depends on what your meaning of it is, or that gray area of the law that drives lay people like myself crazy? But in this case, there are millions of people whose lives are literally hanging in the balance over the wording of the act.
Yeah, that's correct. The ultimate outcome of this case will turn on a relatively technical issue of statutory interpretation. I think everybody agrees that Congress meant to extend subsidies to everybody. It's just not clear whether the text Congress enacted actually accomplished that goal. And so I do think what it will come down to is whether at least 5 justices are willing to say that there is a plausible reading of the text that accomplishes Congress's purposes.
Mr. Flehinger, do you agree?
I do. I think it's very clear. It's interesting. There was a New York Times article, and they interviewed most of the people who were busy drafting this, including the senator with whom I used to work. And none of them, from Republican to Democrat, from House to Senate, ever said that this idea that the subsidies would not be available to people on either exchange set up by the federal or state would happen. So I think that it is a stretch to read this language so narrowly.
So if it's a stretch, why is it before the Supreme Court? In other words, if everybody agrees that that isn't what the language was supposed to be, why is it before the Supreme Court?
Politics. I mean, I hate to say this, but if this were a garden variety federal statute, I do not believe you would ever have gotten this deeply into dissecting 4 little words, exchange established by the state. It would have been read in the context of the larger language of the statute, and we would have said it's clear that the subsidies were meant to go to all parties.
Mr. Singh, on that note, how is it in Washington, where you are right now, that as much attention can be paid to a singular law, and yet the wording somehow got botched?
Well, I do think it's important to note that it's a big statute, right? Depending on which version of the pagination you're looking at 900-plus pages. And the place where the wording is allegedly botched is in kind of a corner of the statute. So it's not in the part of the statute that says who gets subsidies. It's in a portion of the statute that is a technical formula for calculating how much of a subsidy you're supposed to get. And the way that formula works is you sort of multiply 2 variables together. And these challengers cleverly found a way to make one of those variables come out to 0. And when you multiply by 0, you get 0 subsidy. And so, it's an issue that if it wasn't on anybody's radar, and it certainly wasn't, it's the type of thing that very easily can happen during the process of statutory drafting. And it's certainly not the first time something like this has happened when a complex law was passed, with very little precedent for it on the federal books.
EEOC versus Abercrombie and Fitch. A headscarf employee, Mr. Singh, a 17-year-old girl, applies for a job at Abercrombie & Fitch. Because she wore a headscarf, she claims religious discrimination when she got fired. But Abercrombie says they didn't know that she was a Muslim and that she didn't tell. Is this an issue about whether you have to declare your religious beliefs up front? Do you?
I think that is ultimately what the issue in the case will be. When we heard the oral arguments in the case, the Supreme Court, the government takes the position that, employers really have to inquire and make sure that they're extending proper accommodations. The employer, Abercrombie & Fitch in this case, takes the position that no, employees have to put us on notice. We don't want to be having these awkward conversations during job interviews about whether someone is religious or not. And during the oral arguments, it became clear that the justices are probably on the government side of this question. Justice Alito posed a question that I think may wind up resolving the case. He said, well, why can't this happen? Why can't the employer say, okay, we have a no beards policy. Do you have a problem with that? And then the employee can answer and the dialogue can go and the conversation won't be that awkward. But yes, you've identified the issue correctly. I think it will be resolved, relatively narrowly and relatively straightforwardly.
Mr. Flehinger, I ask you the question this way. It involves Abercrombie & Fitch in this case, but this is a rather sensitive area hysteria that is cropping up not only in the United States, but also France, which said that women could not wear full burqas at work. Is this just the tip of an iceberg in lawsuits that we might see coming down the pike?
I think the issue is who's got the obligation to raise the issue in the interview. And it's fraught with possibilities. An employer is afraid to raise the issue because they don't want to raise the issue that we're discriminating.
So then do I have to say what my religious beliefs are when I go in for a job interview?
Well, that's the question. If you as the employee, should you say, hey, I'm a Muslim, I'm wearing a hijab? And a lot of employees would feel uncomfortable because they feel they raise the specter of being discriminated against at that point. And employers at the same token are saying, I don't want to be accused of discriminating by raising what I see as an objective, overt symbol of your religion.
Last case we're going to take a look at is gossip versus gross, and it is lethal injection. This case involves the issue of cruel and unusual punishment, which is protected by the Eighth Amendment. Now, the odd twist about this one is it's being debated because pharmaceutical companies in some countries who are opposed to the death penalty have made getting the cocktail of drugs that made the death penalty seem more humane impossible to get. That means in the end result, more inhumane deaths. Mr. Flehinger, you say that this is an unusual interpretation of the law that is now leading to a new interpretation of the law.
Well, you have two very different perspectives. The petitioner in this case brought a very narrow issue, which is, does the first drug in the three-drug cocktail render somebody sufficiently unconscious that the next two drugs are not painful, that it's not cruel and unusual under the Eighth Amendment? And the more conservative justices who tend to support the death penalty raise the issue, well, isn't this just a backdoor way of going and trying to eliminate the death penalty in the first place? They say that what's happened is that the death penalty opponents have made getting the legitimate drugs that make this go easily and painlessly impossible. I don't think that's necessarily true. The European Union itself has prevented its pharmaceutical companies from providing these drugs because in the European Union, they do not allow the death penalty, nor do they allow their companies to provide materials that will participate in a death.
Mr. Singh, I will give you the last word.
Yeah, I think that the issue has been identified correctly, and I think that the characterization that, a small band of death penalty abolitionists in America has accomplished this sort of, guerrilla war against the use of lethal injection drugs is a little bit fanciful, right? All around the rest of the world, from the Pope to pharmaceutical companies, there is sort of staunch opposition, and that has made getting the drugs a lot harder, and it has made lethal injection a lot more complicated. It remains to be seen whether what the Supreme Court will do is, recognizing that, impose limitations, or kind of throw up its hands and say, well, states can use whatever drugs they can get. And I think there's a real concern that the latter is the most likely result in the case.
Tajinder Singh, who is an attorney at Goldstein and Russell, also a contributor for SCOTUS blog. Also, Kurt Flehinger, a civil rights and criminal defense attorney, joining us here in New York. Gentlemen, thank you both for being with us tonight.